So thanks everybody for joining us for this final group of panels. We've had a great day. My day started at 7 a.m. and is now 5 p.m. here. And my first panel started with a, uh, a doula. And so I'm now ending the day with the pleasure of introducing Bashi Hazard with her presentation called The Human Right to Informed Consent. So that has a very, shall we say, more legal sense than how my day started. So I think it's a nice way to kind of draw the circle around. I want to say before introducing our speaker that there's a Q&A section of Zoom, so we can post any comments or questions there, and Bashi could answer them as she sees fit. And all of these presentations will be recorded, and they're being seen by classes and students, and they're going to be available. So our speaker tonight, Bashi Kumar-Hazard, is a human rights attorney, and she's in the film that we're actually screening right after this called BirthTime in the human rights segment of that film. Recently appointed the president of human rights in childbirth, an international NGO dedicated to defending the human rights of pregnant women and their infants, very much the mission of this conference today. Currently completing a PhD, very busy person at the University of Sydney on antitrust behaviors in maternity healthcare systems. Bashi also has time for 3 children and a legal practice in Sydney, Australia. So it's a real pleasure, and I look forward to listening in, and please take it away without further ado.
Thank you very much, Michael, and it's good evening for you and good morning for us here in Sydney. And thank you very much for joining me. If you'll just bear with me, I will try and share my screen. And I think we're ready to go. Is that all right? Okay, so let me start by introducing myself. As Michael mentioned, I was featured in the documentary that you're about to watch, BirthTime, and it was part of a journey that I had been having after my own experiences with my 3 babies and birth experiences, which were reasonably, perhaps progressively more negative, partly because I am a woman of colour in Australia and small in stature, and I had very big babies. So I tended to make all the doctors that I was working with very uncomfortable with me. And it didn't help them that I was a lawyer and wasn't exactly the most compliant client. Since that time, I've gone from being an antitrust lawyer, and so now I work in both antitrust and in the human rights work. Antitrust work in Australia is very much along the lines of consumer protection, so it wasn't that much of a stretch for me to understand that consumers were drawing the short stick in maternity health care and practices. And so I quite effortlessly moved into this space. So I've been working in this field for about 10 years now, and I have just assumed the chair or the president of Human Rights in Childbirth, which is an active organization based in the US, but we also work with lawyers and advocates across the globe. And I'm currently focusing our efforts on South America and South Asia. Now, we do work with the WHO and UNICEF, and it's been very, very helpful for us because it gives us a bigger picture of what's going on in the world in terms of how women are being treated in childbirth. And I do talk about a lot of that in the documentary that you're about to watch. So today I want to talk about what I think over the last 10 years, it's actually a bugbear of mine. And I think you probably saw a common theme of that going through the entire conference. which is about how women are treated in terms of their autonomy in childbirth. So informed consent has been something that is really difficult for both women and practitioners to deal with when it comes to providing this level of care. And there's a difference of opinion, I guess, as to what it is. And I think there's a great amount of misunderstanding about how it should work in practice. And in truth, after working in this area for about 10 years, it's not that complicated, but we've made it complicated. And I think that's probably what I want to try and explain to you. And so I want to talk to you about what I think are the common issues and how they arise in the field of maternity healthcare practice. And then I'm going to talk about what informed consent is and the law and the human rights dimensions behind it. So what it is, how it works, how it would be applied. And then if you're like me, you would probably get to the point where you're thinking, well, if it's this straightforward, why? Why do we have so much trouble with applying it in practice? And I'm going to talk about some of the barriers to implementing informed consent. And then we'll talk about what we can do, the small things we can do, not necessarily to fix the problem, because as you will see in BirthTime, we talk very much about it being a systemic issue, but we will be talking about what things you can do, small things you can do to alleviate either your suffering or the person that you're supporting and caring for. So what I've put up here is a book that I co-edited with Professor Darlin and Professor Schmid. And what we had done was done a call for authors or research concerning women who refused or rejected systemic maternity health care. So women who just said, if you can't support me on my terms, I will not accept any care at all. So these were what we would call women who free birthed, or women who essentially refused, fought the system, and some of the research behind why they do it and how they do it. And we also interviewed obstetricians and midwives who did things differently. What we also did in this book was we asked all of the women and the contributors to tell us why they did this work, why did they did the research, why they were practicing in the field. And it gave us, it was around the same time that BirthTime was being made, but it gave us a dimension that we never expected. All of those stories made us realize how significant injuries and trauma in childbirth actually is, because everyone who contributed to that book, myself included, had life-changing directions as a result of the mistreatment that they themselves experienced. So there wasn't anyone in this book who hadn't suddenly realized that they had a new calling. So if you're saying, or you hear anyone saying to you that, childbirth trauma is something that women get over, or families or fathers get over, I recommend that you refer them to this book, because there were something like 30 people who told stories in this book who basically said that they went from, path A to path Z as a result of what they'd experienced during pregnancy and childbirth. So let's start with what the problems are. And I'm going to start with the most obvious and the easy one, which is, and I'm not going to say it's easy on the person. I don't mean that it's easy on the person who's experiencing it, but from a research and a legal perspective, these are the most obvious and easy to capture, which is the physical abuse and the verbal abuse that women often experience in childbirth. We don't see in developed nations very much physical abuse, although you would be surprised. In my work, I've had, women being held down during birth and by security guards, or, where their spouses are separated from them and they're escorted into a locked room, by hospital security. I myself, for my third child, was locked in the surgical theatre because I was refusing intervention, and my husband was thrown outside, and he called the police. And when the police turned up, they actually decided to bully and intimidate my husband even more. So it isn't, and that was in Australia. So it isn't actually unheard of. And in many cases, it comes down to the practitioners that you're unfortunate enough to be dealing with on the day. Even strapping a woman down on a bed against her wishes would constitute physical abuse, although many practitioners would be quite surprised if I said that. Disrespect is something that we hear and receive complaints about all the time: verbal abuse, bullying, blaming. Non-confidential care. This is something that's very common in low resource settings where women are strapped to a bed and often, have their clothes taken or stripped off them. And they're in an open space and people are walking past or coming up and down, and they're often, unable to, take any steps to shield themselves or maintain some dignity. Non-consented care, which is something we're going to be talking about a lot today. This is about misinformation and, not providing adequate information for women to make decisions on their own. So before I leave this, I want you to see that the common theme in all of these is the fact that there is no consent. Obviously, no one consents to physical or verbal abuse, but the non-confidential care is about unauthorized revelation of information. Non-consented care is also about not giving someone enough information to be able to make decent choices in their own interests, whether or not the care provider likes it. Then there's a next dimension, which is about misinformed care. So this is really providing false and misleading information. Dehumanized care is also one of the big issues. So this is really where we get into the rub of it. This is depersonalized care, discriminatory care, abandonment of care. These are more systemic elements. So whilst we've got the physical abuse, which we know about and we hear about and all of us are horrified by, what you have to understand is it's really just the tip of the iceberg. What we all have in common in rich and poor settings is that there is a systemic arrangement in place that often disables both care providers and women and clients, because that system will determine how everybody, or dictates to a large extent, how everybody will behave, not just the care providers, but the women, more so for the women and their families, because they don't know what the system is. They don't know what's going to happen next. They don't understand the rules. It's like playing a game of basketball and not actually knowing, where the boundaries are, where you're supposed to shoot, whether or not you can touch your opponent. The rules are not disclosed, and that actually goes a long way to causing the distress that many women experience when they're in hospitals trying to deliver their babies. So we hear also in terms of discriminatory care, and I'll make this point before we move on, we talk about, obliging or respecting adult Jehovah's Witnesses for, their refusal of blood transfusions. But interestingly enough, we don't respect women with attributes such as age or race or disability. And we will curtail those rights in the interests of preventing risk or adverse outcomes. But many of us have come to or become used to the idea that we would have to accept that if a Jehovah's Witness refuses a blood transfusion, they will die. And so there is actually an element of discretion in the way in which doctors respect or afford consent. And that is something that we need to use to recognize that it is very discretionary, and that in fact means more so that in the cases of race and disability or health indicators such as a drug or alcohol dependency, that it is utterly discretionary, and it's something that we need to call into account. So before I move into it, what I was actually already talking about with the previous slide is this idea of systemic boundaries that are put on care providers and women, particularly in institutional settings. And we were very fortunate that in about 2017, Megan Boren and Joshua Vogel, who were both working with the WHO at the time, published an article about the mistreatment and abuse of women in childbirth across the globe. And it was a groundbreaking set of research papers because it meant that the WHO had to take notice of some of the systemic concerns that were happening, but also because they were able to really analyze how this abuse was taking place. Now, from my perspective as a lawyer, as I was saying before, the intentional use of violence is a much more straightforward issue because you can hold someone to account. But when it becomes a structural form of abuse or disrespect, there is a bigger challenge at stake. And what we often find is that if you go after a particular care provider for the intentional use of violence, the institution will make a decision as to whether or not to support that care provider, depending on how much the decisions of that care provider affirm the structural sort of delineations of how the organization works. That too is a cause of confusion, but this research has made us recognize, the extent to which you will receive an institutional response to a particular complaint. And what it also shows us is that in some cases you can go target an individual, but it will hardly do anything to change the institution. And we all know that, right? We all know that you can go after a particular person and nothing will really necessarily change, even if we all decide that that's a bad person and that's demonizing. That one person, it doesn't really mean, and that's how we see maternity healthcare rolling out across the globe. We can target particular individuals, but we don't seem to be seeing any real cultural change on the ground, particularly when it comes to controlling women in childbirth. So one thing I should say before we move on is that these problems with abuse and disrespect are global. They are happening in all settings. They may be a little different, or there is an emphasis on different kinds of abuse or disrespect, but they seem to be overall happening everywhere. So what happened as a result of our research and the work that I've been doing in this space for the last 10 years is that it's allowed me to crystallize a few questions that I think come out of these issues that we've talked about and the book that we've produced and I think these are the questions that often are sort of hanging in the air in every birthing room, in every hospital. Who's got the final say here? Who's in charge, really? Why are you telling me to do something like I'm a child? And when a doctor comes in and says, your baby does not like what you're doing, I remember a doctor coming in and saying to me, I've just looked at the monitor and your baby does not like what you're doing. And the thoughts that flashed in my mind, although I was in labor, was how on earth would you know? How would you know? My baby's moving inside of me and I can tell what's happening. How could you possibly presume to speak for my baby? And in actual fact, that is probably one of, and I didn't know this at the time, one of the most pressing questions in this field. And this is about who speaks for that unborn baby. And I know that this is a very vexed question in the US at the moment, but in fact, that question about, who has the moral or legal authority to make decisions for an unborn baby or a fetus is going to have significant implications on maternity health care as well, and whether or not we can alleviate the amount of abuse and disrespect, because there is definitely a strong connection between those practitioners who believe in the rights of the unborn baby and the degree of abuse and violations in the way in which they treat women, the patients who are strictly speaking under their care. So I am going to answer these questions through my talk because I think it's probably more helpful to put them into context. But just to briefly answer them for you from a human rights perspective, do women have an obligation to obey their doctor's orders? No, they don't. Do doctors and midwives have an obligation to support women on their terms? Yes, they do, provided they're practicing in a facility that has the capacity to afford those those terms or support those terms. Who has the moral and legal authority to speak for a birthing woman? The birthing woman alone and nobody else. No partner, no husband, no mother, and no guardian. As long as she's competent, as long as she's conscious, she speaks for herself. Who has the moral and legal authority to make decisions for the unborn baby? At law, and in human rights law, until that baby is born alive and separate from its mother, the mother speaks for that unborn baby. And what is the place of the unborn baby, of its rights and interests? Now, this is a very interesting question. I know it's being hotly disputed right now. But again, in law, there is no doubt that until and unless that baby is born, it is not regarded as a separate legal personality. And so there's only one person who is entitled to speak for that baby. The law speaks in that way because you have a human being right in front of you. And as a care provider, your obligation is to that human being right in front of you. I know many of you at this point are going to be saying, well, hang on, that doesn't make sense, because I've seen cases where, they've stepped in and said that this happened to the baby before it was born. I am going to explain that to you because, yes, it has been a curveball in maternity healthcare, and I think it's caused a lot of problems for women and consumers of maternity health services. So let's start by talking about what informed consent is and how it works in practice. Let's break it down. I like to think of it as two sides of a coin. So on the one side, you've got the obligation to inform. And then on the other side, you've got the right to consent, and that includes the right to refuse. So it rests on the assumption that as adults, competent adults, despite the esoteric nature of medical knowledge, the average person is more than capable of assessing their medical needs, and they're more than capable of making decisions based on their own interests, their best interests, including if it's a decision not to follow a doctor's advice. Now, take a step back and think about that. There is no way that a doctor can understand all of your personal circumstances. And in fact, most of them don't have the time or are interested in understanding your personal circumstances. They are there, you present them with a condition, and they're there to treat it. Now, the reason that you have the final say is because whatever options they're offering you, you're the person who has to bear the consequences. And so you're the best person who's best placed to make a decision, having regard to all of those needs and consequences. I have had women who've said to me, I cannot do this because my husband works on an oil rig and I can't even reach him more than once a week. So if I have a C-section now, who's going to look after my other two kids? I need to, find a care provider that's going to support me for my own needs. And she can't, because every doctor around her says, I'm not willing to take that risk. I won't take her on. And that's where you've got an antitrust problem, because I think we need doctors who are willing to step in and say, well, actually, I'll step up and I will respond to this consumer or this client based on her needs. So going back to the point is, when you have informed consent, you can't actually have one without the other. So you can't have consent without information. It's not consent. And that was the case of Ivy in Bolivia. So this is a case of a refugee who was told she had a forced C-section while she was in a refugee center. And what she didn't realize until several months later, when she was trying to conceive again, that she had been given a hysterectomy. And when she challenged the health service that gave her the hysterectomy, she was told that her husband had given her his permission. And we all know that that is actually a violation of her fundamental human rights to autonomy. But the state of Bolivia didn't agree with her. They decided that it was in her best interest to have done the hysterectomy because they felt that she probably wasn't in a position to afford to have any more children. Now, she had to take her case to the Inter-American Court of Human Rights, which was rightfully appalled that the hospital not only gave her a hysterectomy without telling her, given the health consequences for that, but that they took or claimed that they took permission from her husband, who she was already estranged from because she was obviously fleeing the country. And it was not an emergency, and she was obviously not incapacitated, but she was nevertheless ignored. And the word autonomy was obviously raised here, and I'm going to go on to talk about that. When we hear women, particularly women, saying that their care providers have told them, and this is something I hear all the time, I'm going to put a cannula in right now. That is giving information, but it is not consent. Just because somebody sits there and says, okay, doesn't actually mean that it's consent. And we're going to talk about what consent looks like. So to inform, and this is what we're talking about, the obligation to inform your client or your patient, depending on whether you're a doctor or a midwife. Doctors refer to, or physicians refer to women, pregnant women in their care as patients. Midwives refer to them as clients because from the midwifery perspective, they're not sick, so they're not a patient, they're a client. And I think there's a different dynamic there that's actually quite significant to pregnant women because it frees them from the fear of thinking there's something wrong with them. They're not, there's nothing wrong with them, they're pregnant. So let's break it down. The duty is really to inform and to advise and to support. So you answer questions, you offer alternatives. There's really no I'm the expert here. There's technically speaking really, and in law, there should be no place for I'm the expert because, and I'll go on to explain why, because women and plaintiffs have been held responsible for their own decisions. And where the doctor has overridden their choices and said the doctor's the expert, then the doctor has actually been held responsible for decisions they claim were not theirs in the first place. Shroud waving. I'm going to talk about shroud waving in a minute. And then there's false and misleading information. So we see this is very common in facilities where the doctor might have already become a little bit annoyed with a woman who is resisting standard care, and they will actually not offer all of the alternatives or give the family enough time to consider the alternatives because they're already annoyed with the family or the woman in their care. The other thing that we see very commonly, not so much with physicians, but with midwives or hospital nurses, is the bullying and the badgering. I can do this now, can't I? All right, I'll give you half an hour and I'll come back and then we can talk about it again. Really, there seems to be a space in maternity healthcare services where no actually apparently doesn't mean no. And we're going to talk a little bit more about that because no does mean no. So this is what I meant before about shroud waving. This is a study that was done in Canada by Hall and colleagues, where they did this research to elicit some of the attitudes of care providers in a facility, mainly physicians. And this was something they didn't anticipate. So they are medical researchers themselves, and what they were very surprised to hear some of the physicians talking about pulling out the dead baby card. We hear this all the time. And can I tell you, even when women call me, perhaps 18 months after the birth, when they start saying, and then the doctor said that if I didn't do this, my baby was going to die, they start weeping uncontrollably 18 months after the event. So the impact and the significance of saying those words to a woman in labor is massive, and yet so underestimated, because I still hear, from clients who are saying that they pull a dead baby card on me or shroud waved, even though there was obviously, when I review the hospital notes, there was no emergency. There was just, a team getting incredibly annoyed because the birth room or the birthing suite wasn't being vacated in good time. So let's get on to what consent would look like. Consent really, before anything else, needs to be freely given. So when you say to someone, I'm going to do this, you're not actually giving them the opportunity to say yes or no. Freely given means no pressure, no repeated requests, no badgering, no challenging, and certainly not you have to decide right now. The truth is, unlike any other situation, you have 9 months of a reasonably well patient or client who presents to you. You have several antenatal appointments. You have plenty of opportunities to have these discussions. And what we call privately practicing midwives. So these are midwives who work with women, and they accompany them to wherever their chosen place of birth is. And they conduct all of the care and the postnatal care. So they're debriefing with the women, usually for 6 weeks after the birth, and caring for them and the baby. They seem to have a very different approach to eliciting consent. Those conversations start from the very minute that they engage with these women. And these are lengthy conversations, appointments that go on for an hour at a time, where they're exploring alternatives and options for women, which really should be a standard of practice. And it seems at the moment is only being reserved for those who can afford it. But that is actually what you need to do for consent. The other thing about consent is that it needs to be specific. There is no such thing as a blanket consent form, because you haven't actually got a specific situation in which to get that consent. So in law, the discussion is that if you want to approach me, if you want to even put a finger on my shoulder, you have to ask for my permission before you do it. If you even put me in a corner and your finger is approaching me so that I can't escape, and it seems inevitable that you're about to touch me and you don't ask for my permission, it's assault. Everything in law, whether it's in civil law or in criminal law, in those situations is assault. And yet, quite extraordinarily, if you put on a white coat and stand in an institution, it seems that you can do, and you're dealing with a pregnant woman, it seems that all those laws don't seem to apply, but in fact they do. And it's about time that we asserted them. So every single administration of treatment, whether it be a fluid bag, an antibiotic infusion, whether it be to turn someone over, whether it be, and in particular, whether it be to do a vaginal examination, requires an explanation of what is being done, or what is to be done, why it's going to be done, whether there are any alternatives, and then some time for the person to think about it and agree to it. Now, yes, this seems complicated, but there are plenty of avenues in which those conversations can be had. The problem here is that maternity care practices become quite lazy about eliciting informed consent. So it's become, shortcuts have been taken across the board, and that's got nothing to do with emergencies or time constraints. It's got everything to do with financial imperatives. And what has happened is that as we've become more and more, as women, extraordinarily adapt to these situations, and so too has the boundary of what is acceptable in terms of violating consent has shifted. And this is what I mean when I talk about the physical abuse being the tip of the iceberg, because as those systemic practices build and build and build, they will inevitably get to the point where it's okay to hold someone down while they're giving birth, or to force them into having surgery. It's really just a matter of degrees. And this is how it starts. It's with all these small incursions that we think are okay. The other thing it has to be is enthusiastic. I cannot stress this enough. When you ask someone a question and they say, oh, okay, or I think so, it's not consent. It's not a yes. It's not enthusiastic. It doesn't mean I understand what you're saying and I think this is a good idea for me. It's just saying I am completely and utterly intimidated. I don't know what's going on, but I'm going to put myself in your hands because I trust you. Now, this is where the rubber hits the road, because when there is a liability claim, the doctor will turn around and say, but I put it to them and they said yes. And of course, the woman will turn around and say, well, actually, you told me and I went along with it because you're the expert. So I guess my view in this space is that you can't have your cake and eat it. If you are a practitioner and you want to control a situation, then you can expect to take the fall for it, because that's exactly where we've headed. And I'm going to talk about medical liability and why it's such a problem in this space in a minute. Obviously, as we've been talking before, it has to be informed. Now, I'm going to stress something here. This is not an invitation to test somebody's intelligence or capacity. The law is very clear on this. You don't need a PhD to be able to consent to something. You just need the information. It is not the doctor's obligation to assess whether or not you're capable. I've had clients who said, well, as far as I'm concerned, the sky is blue, and I'm not doing that today. And that is a perfectly acceptable justification. Her obligation is not to understand you. That's your obligation. Your obligation is to understand as a practitioner the material and to share it with the patient or the client. The client can basically accept it or refuse it on any terms. And of course, last but not least, it can be reversed. I get that the hot preparations are underway, and I get that everybody's feeling a little bit inconvenienced. But in fact, you can withdraw no. Now, you will also see that this is probably 101 consent education for sex education, or we hope, in high schools and universities. And that is, in fact, what the law expects. So individuals are being held to account when they come before the courts for failing to afford these sorts of protections to each other, or respect and obligations to each other. And yet we find that in maternity care, these sorts of basic obligations that we impose on everybody else seems to be overlooked every day. And we need to understand why. So the first thing I'm going to do is explain the human rights principles behind informed consent. So there's two elements that are relevant to informed consent. The first is the right to autonomy, which is the right to choose or refuse a treatment option, as I was saying before. And the other is bodily integrity. So this is where I was saying, if somebody wants to approach you or to touch you or say anything that may affect you physically or mentally, then you have a right to say yes or no, or to move away or to resist. It's your decision ultimately. So informed consent is the legal principle that's crafted on the basis of these two fundamental human rights. We see that you can't, the both of them feed together into this idea. And I guess the point here that I keep trying to make is that there really are no ifs or buts. If we want to respect human rights for women, there can't be any exceptions. And there's a reason for that. Okay, so we talked about autonomy, and this is an extract from a working group report that was done in 2016. This was sort of at the beginning of the millennium and the sustainable development goals that were being crafted by the UN. And some of the more ambitious goals of that was to try and reduce maternal and infant mortality and morbidity across the globe. But of course, this were already at that very early stages, reports emerging about how women were being mistreated in relation to their reproductive rights, including in maternity health facilities. And it was starting to emerge, particularly for the WHO and the UN, as something as a bit of a shock. Whilst it was expected in some of the low-resourced nations, it wasn't something they expected in high-resourced countries. So this report came out of some interviews conducted in the US, Senegal, Turkey, and Iran. And I think the feedback that came from the report was that, there seems to be a significant misunderstanding across all those countries, and that included the US, as to the bodily autonomy and the human rights of women, particularly in relation to their reproductive rights. And the last phrase, which is why I've put it in bold, is that this is a matter of law, amongst other things, a woman's right to equality before the law. So let me explain this very simply. When a man walks into a hospital and he says, certain treatment options are offered to him, and he says, well, I don't want that. And the doctors will say, well, it's your call, but okay. If a non-pregnant woman walks into a hospital and she's offered treatment options and she says, no, I don't want it, and I'll say, well, it's your call, okay. But when a pregnant woman walks into a hospital and she says, no, I don't want that, and then she gets either bullied or coerced or harassed or physically constrained, or a court order is obtained in order to make sure that she gets that treatment option, whether she wants it or not, what we have essentially done is created a second class of citizen. So we have said to her, you are a means to an end. We're not doing that treatment for you, a citizen with equal rights on your own terms. We are doing it in order to save the being that we believe to be inside of you. And we will do that regardless of your choices. So what we've essentially done is enslaved that pregnant woman on the basis of her pregnancy. You've created a second-class citizen, folks. And that's really the constitutional reality of what we're doing every day when we coerce and violate pregnant women's human rights. And that is essentially what we're dealing with right now. So going back, based on what we saw in this phrase that's extracted by the Human Rights Council, going back to those questions, I will answer the first two. Do birthing women have an obligation to obey doctors on their orders? No, they don't. They simply don't. There is no reason, in fact, for them to accept anything, just like there is no reason for a non-pregnant woman to do it, and there's no reason for a man to do it. Pregnant women can make decisions on their own terms. So let's go on then to the some of the human rights instruments that have been used to hold care providers to account. And that has been a significant change. Somehow through COVID, in the last couple of years, there's been some developments in this field, which I want to share with you. I want to say this, that 10 years ago, when I first started this work, the phrase obstetric violence was taboo. And yet today, just, working with you all through this conference, I've seen that phrase being used, in conversation and on slides as if it's part now as a given. And I don't know whether many people here understand just how hard fought that was, because it was actually for a while there being treated as a rude word and a measure of significant disrespect to physicians. But I will go on to explain how it actually came to be. So the UN Convention on the Declaration on the Elimination of Violence Against Women. Now, this convention, as we call it, CEDAW, is about protecting or defining and protecting women from violence. And it's framed in a way that talks about, in the very opening definitions, frames violence as physical, sexual, and psychological harm or suffering to women. And it includes threats of such acts. So this is what I was talking about before. If you corner someone, even though you haven't actually made physical contact with them, if you intimidate them enough, the law says that you have potentially assaulted them. And so this includes acts such as arbitrary deprivation or coercion. Now, the psychological element of harm is something that is seriously, disregarded, or significantly disregarded in the provision of maternity health care. And I do think there's an element of deliberate intention behind that. I think there's almost a blinkered view about the psychological harm that we cause to women in pregnancy and childbirth, because if we were to take it into account, we would probably have to refashion maternity health services, because they're structured that way, and there's no two ways about it. But as a result of this convention, in 2020, a case was brought in Spain against the state of Spain by a woman who was a young, healthy woman, a primate. Also, she was having her first baby. She attended hospital in the very early stages. And this is very common for women who are having their first baby. They're very anxious to make sure that they're doing everything right. And they will go into hospital and say, look, I'm having, early contractions. I just want to make sure everything's okay. And unfortunately for her, they decided to admit her, even though the labor wasn't established. She had no complications. There was no reason for them to expedite the pregnancy or the labor. But in any event, they decided to induce her, even though she wasn't really ready to progress into that stage of labor. She was subjected to so many vaginal examinations from memory that she ended up with a baby that was born with an E. coli infection and had to be put in intensive care for a week. She was separated from a partner. She was given an episiotomy. She had a ventouse delivery, all of it without any consent. And she didn't know what was going on for most of the time. She sustained significant internal injuries. And she was strapped down for the entire duration and put in stirrups, so she couldn't even get up and move. And she said that she kept asking the staff what was happening and why she was there and why she was left alone for such long periods of time, and no one ever answered her questions. So it was a little bit like being abducted by aliens from her perspective. And I think it's something that, it's a phrase that keeps coming into my head all the time when my clients talk to me about what they've been through. It's like some bad movie about being abducted by aliens, and being experimented on. So the CEDAW committee was reasonably appalled that a healthy young woman who simply went into a hospital to get a little bit of advice. Spain has a health system that's very similar to Canada and some states in the US, and in Australia and New Zealand, where they've got a private and public health system. And the public health system is actually reasonably well funded and is accessible by all. So that was really a responsibility of the state of Spain. This woman brought her claim in state courts in Spain and was lost at every stage. And that was because the courts felt that she had a healthy baby and that she would get over it. And the only thing they did award her was damages to her husband because he'd been denied sexual relations for a couple of years. So one of the things that came out of the judgment is that the court talked about the obstetric violence report that was issued by the special rapporteur a year ago. And I'm going to talk about that in a minute. But this is it, folks. So this is a court that is now calling violence against women in childbirth and pregnancy as obstetric violence. Obstetric violence is now a phrase, and a legal phrase. And it is, in fact, specially assigned to the violence that's experienced by women in facility-based childbirth. And the court has also acknowledged that it is a form of violence that's been shown to be widespread and systematic in nature. And it is. For all of us who work in this space, we know that it is widespread and systematic. So let's talk about the Special Rapporteur's report. So the court was referring to this report that was issued in 2019. So the UN now has a special rapporteur who investigates and reports on violence against women. She, at the time, the rapporteur put a call out in early 2019. She gave NGOs across the globe, I think, 2 weeks to file, to submit reports on what was going on a nation state basis. And she received something like 2,500 reports, despite the fact that, and I can tell you, it may not seem like a lot, 2,500 reports in 2 weeks. But when you're talking about women's advocacy groups that really function, on a dollar and an oily rag, that's a big deal. There were 2,500 reports. Some of them, my organization submitted a 60-page report, which basically brought together all of the complaints that we'd ever received. And we had categorized them on the basis of each country. And they, the reports were extremely confronting. And also, the Special Rapporteur's report was extremely confronting because she actually affirmed what women across the globe already know, which is that women are being frequently denied their right to make informed decisions about the healthcare they receive in childbirth and in relation to reproductive health services. And that it is a human rights violation that states, governments should be held responsible for. And this is really comes back to the core of what I was talking about in the beginning. This is about the systemic deprivation of the right to autonomy as soon as they come into contact with a healthcare facility. So this is not just during labor and birth. This is about every antenatal appointment where opportunities are missed to share what the system is going to do, what the hospital protocols are, what to expect from time of admission to the time of delivery, whether or not the hospital has preferences on time limits. I know from my own work that every single facility has a comfort zone of how long they will permit women to labor. The more conservative the facility, the more restricted that time frame. And it's often very unrealistic if you were to compare that with actual labor times for women, whether they're in their first childbirth or subsequent babies. It's often very, very constrained, and it's usually determined by what insurers will say is a tolerable phrase before the care providers can be sued. And so she also goes on to call on things like, the less obvious elements of violations of autonomy, such as the use of hospital protocols. Now, I used to think that it was just tardiness or an overworked staff, that women are not offered information about, hospital protocols or preferences or forms to sign, consent forms to sign. But in fact, I've come to realize that it happens so systematically and so consistently for something that, is quite predictable. If I know that you often hear the mantra in maternity healthcare that birth is unpredictable. You never know what's going to unfold. Now, there is some truth in that, but you couldn't compare that. If you said to me, look, you've got bone cancer, and I can't actually predict how long you're going to live, but I can tell you what the treatment options are going to be, and I'll spell them out to you. In actual fact, maternity care is not that much different. Yes, the outcome could not be predicted, but the strategies and the different options that you have in order to manage those outcomes are all there. They've already been taught to your care providers. Your hospital already has unlimited numbers of protocols and standards of practice that they can call upon in order to discuss or manage those eventualities. And the issue we have here is that women and families are not told any of those things. They're often just being told that they're dealing with a crisis. There is no crisis. There are contingencies for all of those crises. Believe me when I say to you that the lawyers already know all of this, because we see this playing out in court case after court case. Those contingencies are usually already predicted, and there's already a bunch of either hospital standards or protocols to manage them or insurance guidelines to manage them. And insurance restrictions are also another thing that are not disclosed to women and their families. If you have a doctor that is not allowed to do VBAC, that doctor really, in the interest of your consumer rights, should be disclosing that information to you at the point of the first antenatal appointment. I do not have the authority to do VBAC. If you are interested in that, can I recommend you to A, B, C, or D? To do anything otherwise is misleading and deceptive and in breach of your basic consumer rights, let alone your human rights. So you must be thinking as much as I was, I think, after my third baby, which was, well, why is this happening? I am a lawyer and I feel like I've stepped back in time. Why are these people treating me like a child? Why am I not being allowed to make decisions about my own body? And why are these people presuming to speak about something that's happening inside of me that no one could possibly know or even gauge from a machine? And so I actually, and this is part of the reason why I'm doing the PhD in, antitrust behaviours, because I'm trying to understand how this came to be. And I think there are a number of issues that feed into this mess that we call maternity health services. And amongst them, and I will go on to talk about them, but in the first place, obviously, as I've already hinted at, it's medical liability, law and practice. Now, I am not a fan of medical liability law because I actually think it works against women, and I think it works against physiological childbirth. I think we need to understand that insurers are profit-driven enterprises. So they work to minimize risk and to maximize profit. So if they tell their members to intervene because the law supports that, you know, a doctor would be out of their mind to not do that, and to not respect that. Of course, no doctor wants to be left without insurance and to lose their practicing license. So there is actually a symbiotic relationship between insurers and doctors, and to some extent the courts, to support each other and maximize the restrictions that they put on women. But the people who bear the brunt, obviously, are women. And for that reason, I think it's part of the reason why I think that mental health concerns are so dismissed. There is, in fact, a concerted drive amongst insurers and doctors to not allow mental health factors to come into play in damages claims, because to do that would be to shift away from this risk minimization process that they have adopted of prioritizing the unborn infant. And part of that also is because the law, damages in medical liability laws will give more money for injuries to an infant over injuries to a woman. So cases are also unpredictable and punitive. And the problem with that, of course, is that it doesn't teach the practitioners anything. They become very stressed about it. They become actually more risk averse, and they are less likely to work with women and afford them autonomy because they think their future is at stake. And of course, what you're really doing is allowing doctors, not doctors as much as lawyers and courts and insurers, to dictate what is good practice, on the assumption that that will work normally. It may work normally when it comes to one patient. So you are the patient and, you know, your doctor's not done the right thing by you. But when the doctor claims to be juggling two patients, which strictly speaking, they're not supposed to, but the law has said that once a baby is born and is alive, then the baby can sue in its own right. Doctors start preempting what's going to happen, and they will prioritize the interests of the infant as against the unborn infant as against its mother, even if their interests are aligned, in order to protect themselves. And I think that's just, to be fair, I think that's just human nature. We would instinctively want to protect ourselves. So I want to talk about how it is. Sorry, before I move on, one of the problems, of course, with medical liability is that it is also infusing into medical and institutional training. And this is a big problem, because what I found is that in maternity health services, it's become such an animal of its own that we see doctors and midwives or health administrators talking about the law and interpreting the law in order to conduct training for their own personnel, which really is to me a very interesting dynamic, because in the same way that I wouldn't, as a lawyer, pretend to know what an obstetrician can and can't do, I find it very curious to hear hospital administrators and doctors talking about what the law says and means. And this is a case at hand. So this was a case that came out of the Supreme Court in the UK. I'm running out of time, aren't I? I'm very sorry about that. And in this case, this was a woman who was a medical researcher, and she was significantly overweight, and she was asking for a C-section, and the doctor claimed that she had a policy of not disclosing the risks of a significantly overweight person having vaginal birth, because everybody would ask for a C-section. And the court was somewhat appalled by that treatment, because they were saying, look, gone are the days when, on becoming pregnant, you lost your capacity or your ability to act as a genuinely autonomous human being. Now, this is not controversial, having regard to everything that I've just said, but this is probably the most interesting thing that came out of the case. So the interpretation of what the doctors' interpretation of what the court was saying was not about patient autonomy, but about warning women about their physiological birth. Now, everybody knows that going into labor is a physiological function. Okay, it's like relieving yourself. You really can't control that process. So warning women about that delivery risk is almost insane. What's misleading about this is that the injury that was sustained by the woman had to do with the forceps or the ventouse that they used on her, which significantly caused her internal injuries, and which lasted for at least a decade. But that's not the conversation that's being had here. The conversation is about fear mongering about what is a physiological birth process. And that is actually, to me, very interesting. And we have see the same thing in the US. You've gone from this, which is patient-centered autonomy and patient-centered care, to a doctor talking about, how the case should be dismissed and we should be, reasserting medical paternalism. Shervanack is a well-known obstetrician who I think at one stage was the president of ACOG. So really, I think to cap it off, or round this off today, we need to talk about, what is missing here, which is patient rights or an understanding of women's human rights. And I think there is really a gap in what we know and what providers know and what health facilities know. And in the 10 years that I've been working in this space, I actually have gone from, as I say, thinking that it was just, one of those things that are unfortunate to realizing that it is actually intentional. And so one of my big missions for the next few years is to see that women understand what their rights are in pregnancy and childbirth. And certainly that will be the aim of our organisation going forward, since I have taken over the reins. So I'm going to stop there because I realise I've just talked too much. And
So,
has anyone? Oh, yes.
so Bashi, we could see if anyone has a question in the Q&A section. I know I have a question or two.
Mm-hmm.
I have to say I found that totally fascinating. I felt like I got a law school education in, and I come from a family of doctors and lawyers, and I'm the youngest who's an English professor working at a college, but I've been in the position of I've been connected to VBACs and I've been connected to all of these things, and it really hits home. I texted my wife during your presentation.
Really?
Yeah, maybe I'll just begin with a question. I could just be an open observation question that you can run with is, some words that come out, a kind of word cloud from your presentation. I hear efficiencies. I hear this fascinating word, which comes for America. You have this technocratic society where everyone is an expert. Expertise is what it's all about. And so you had this fascinating moment where you're talking about the relationship is not exactly about expertise, and this expertise can conveniently be disowned as well, that somehow the doctor is both an expert but then is not quite liable. It's just a fascinating window into what modern society is today. It's streamlined, it's efficient, it's technocratic, it's expert. You kind of give up, you don't have the ability to even use your body and all these things. Can you just unpack how you can both be an expert and then not be an expert at the same time, like in a legal case? I was just really fascinated by, because I could just imagine you in a courtroom arguing this against somebody. So could you talk a little bit about that?
Right. So look, I understand what you're saying, and it comes down to rights and responsibilities. So it plays on both sides. So we see this in the courtroom all the time, which is, that the doctor understands that they took the initiative and made certain recommendations. And that's fine if everything goes well and everyone's happy. Usually what you have is behind the scenes, a woman who will go home and she will probably cry for, 9 to 12 months maybe, and get on antidepressants or whatever it is, and get some therapy, and life goes on. But if something does go wrong, what we see in the courtroom is that the doctor will say, well, I put the options to, so and so, and she took them. I explained the risks and she took them. But then when the woman takes the stand, she will usually say, well, hang on a minute. You told me that I should do this. So the conversation is very different. What the doctor says said and what the woman says she heard are two very different propositions. She says, you told me this and I trusted you. And what we can't capture in the courtroom, which has really taken me many, many years to understand and distill, is that there is an element of I'm the expert in that birthing suite. And usually most women, very few, I think, I would say no more than 5% would stand up and say, no, that's not acceptable. I'll make the decisions. I'll make the final call. Thank you very much. Very few. And I usually find that they're people who are deeply religious, or have a very strong support mechanism, or, are wealthy enough to count as royalty. So they're already being given the golden treatment, and, they don't have to fight that hard. So we're talking about a very small percentage. 95% of us will walk into that space. It's really set up against us. Okay. The room is very bright. There are people coming in and out. As laboring woman, you're disheveled, you're messy, you're messy, you're probably still in your pajamas. You can't think for very long because you're between contractions. And then there's all these very busy, very important, very well-dressed people shuffling around you, telling you to do things. The power dynamic is established the minute you walk in there. This is something that doesn't quite get translated into the courtroom, but it is crystallized in the minds of the people who are giving evidence. So the doctor is saying, what's the big deal? This is an everyday process. I gave you the information, you made the choice. The woman is saying, actually, no. I walked in there, you took control, and you said you were the expert. I did what you told me to do, and look where it got me. So I guess it's a double-edged sword. And I keep saying to doctors, if medical liability in maternity healthcare has become the bane, it's because you made it that bane. You forced this track where you claimed to be the expert, and you took the rights away, and you therefore took the responsibility of autonomy away from your clients. And so you will wear the burden. That's really why it's become such a runaway train. You've captured probably the thing that I didn't want to go into because I thought we were running out of time, but that really is what's playing out in maternity health liability claims every day, which is that doctors have decided, and it becomes a vicious cycle. So the doctor thinks, next time I'm going to intervene earlier and faster, and I'm going to tell her even less, so that maybe then she won't accuse me of doing the wrong thing, or she won't figure it out. But someone always figures it out, because that's when, if women are angry and upset and in enough pain, they will find a lawyer who's willing to help them.
Right.
And they do. I mean, I have never, in the 10 years that I've done this work, I have never had to even advertise my name. It simply is the case that women will find me and they will ask for my help, because that's how motivated and angry and frustrated they are. And they're just the handful that have realized that they've been tricked or fooled or misled. And they're furious about it, because their pain and suffering is very real, and it goes on for much, much longer than that birth experience. And I've also represented women who rejected their infants. And that should be enough. And it doesn't matter whether that's 1 or 5. That one should be enough for all of us to be paying attention, and yet we don't.
Yeah, I mean, the way you describe living with it afterwards, I've been through that, I know, with my own partner, and it's something that you don't even really hear in the popular culture. You hear of a kind of immediate depression, but you don't hear of the feeling that you once were kind of part of this medical industry. I guess a final thought I had was you described that you had an analogy which is kind of clever and obvious and not obvious about cancer, where when you are being treated for cancer, it's like you have this disease and you have to kind of think about it and you have to weigh options. In my experience, when you come into a birth place, this happened to me. They turn to me and say, "We have this situation with twins, and you have to make a decision like that." And you're suggesting that this issue is a vicious cycle because it becomes faster and faster and faster. There's
Right.
and that is violating the consent when really it's like not completely, but it's pretty detached from a biology in which these decisions need to play out at least in a few hours, if not, you know what I mean?
Yeah, and I'm assuming that you already knew that you had twins, and that your
Right.
wife was carrying twins, and so there would have been several contingency plans, and there should have been. So I'm not a practitioner, a medical practitioner, so I couldn't give you chapter and verse, but from the clients that I've represented, there are different options depending on whether your wife goes into labor early or whether she makes full term, the way in which the infants are lying, maybe they're transverse, maybe one of them's breech. All of those options would make it feasible in terms of whether or not your wife's going to have a natural delivery or normal delivery, or whether or not they need to intervene. And those discussions could have been had from I don't know, at least somewhere in the second trimester. There was
Right.
no reason to be having those discussions in the birthing suite at that crux. All of those options needed to have been explored. And look, I only stumbled on this because for my third birth, I had two C-sections for my first two births, and they were unindicated. I just chose the wrong care provider. She was really just very cautious, and decided, she profiled me. She decided that I was a small woman and I probably would never be able to labor. And so, she induced me and everything just really went to pot. And I ended up having two C-sections. But for my third pregnancy, I knew that I probably would jump off a cliff if I had to have another C-section. I can't explain it, but my mind told me that my brain would not survive another one of those events.
Right.
And so I found a midwife to help me and support me, and we were booked at a hospital. But the service that I received from the day that I went to see her, every appointment went for an hour, and there wasn't anything that we didn't discuss in terms of options. And I learned from her, in that one pregnancy, more than I had learned from a, highly paid obstetrician, the same obstetrician for two pregnancies. And the confidence and the peace of mind and the trust that I built with her was extraordinary. So much so, when I went into labor, all I could think of was that she was coming and that she was going to be with me and that she
Right.
had my back. That is a very different dynamic to what we all experience going into hospital every day. So I am not at all surprised that that doctor would have come in, consulted with you. That's against the law because it's your wife that he should have been talking to, and then, of course, told you to make a decision, like at the last minute, also
Right.
not informed consent, and made out as if the twins were a new event and a high risk event. That's not true. We all knew, you knew you were having twins, and you knew that it was going to end up being a high risk or not high risk eventuality. There was plenty of opportunity. So you essentially were denied informed consent. That would
Um,
be my legal.
Maybe that will be the final word of this conference. But Bashi Hazard, I have to say that it's a really fitting ending, at least to this part of the day before we turn to the film. And I think you gave me a legal education, really, really deep, very clear. On your way to your PhD, I can see you as a professor lecturing hundreds. Very impressive. So I want to thank you and thank everybody and remind everybody that this is recorded so we can go back to these and use them in the future. And I'm sure that people will get a lot of use out of it. But thank you a lot. I thank
Thank
you very
you.
much, and thank you
Thank
so much
you.
for your expertise and your wisdom and the way you're helping people and advocating as well.
It was lovely to be here. Thank you for having me.
Okay, well, have a good morning and the rest of your day.
You too. Bye.
All right, bye bye, bye everybody.